Nobody cared who I was until I put on the mask. Yeah, I used to be like kind of just a nobody, just kind of working their job, doing whatever before the YouTube channel, and we have now officially hit monetization. I'm so stoked. I can't say thank you enough. If you're watching this video, you are part of the Squirrel Pup family, and I just want to take a minute before this video starts and say thank you to all of you. If you're watching this video right now, thank you. The channel has had some pretty explosive growth the past few months. A little bit over, actually it's been a little over 1 month, and we're almost at 1.5K, and it's just, it's humbling. It's really the only word I can use to describe it. It's been night and day, huge positive impact in my life, and I have all you to thank for that, and that's not lost on me, to quote Darrell Brooks himself. That's not lost on me. So anyways, we're going to take a look at the whole music video debacle, and Darrell Brooks opening a dough. Open the dough! Open the dough! So, I'm not going to waste any more of your time. Thank you again. Let's just jump on into it, shall we? Let's get this.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection, I don't consent to being called their name.
They call me her, they call me Jane, that's not my name.
Misleading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection, leading.
It's time to stop!
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Please identify 175.
This is
Objection. Relevancy.
I'm Michael Jordan. Stop it. Get some help.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection, leading.
Hey, hey! Not nice.
No, thank you.
No, thank you.
Do you need to leave? No, man.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled or sustain?
Overruled.
He said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry. I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that.
Golly. Judge Dorow, she is a freaking angel, man. The way she just hit me with that sorry with the Wisconsin accent, oh, it fucking hits different. Wisconsins, they're so innocent. That part of the country is just so blissfully kind, like to their own detriment. It's horrifying to look back that this fucking turd goblin was running amok, wreaking havoc among them for the past 40 years. It's like almost surprising you didn't murder somebody sooner.
For any confusion I may have caused.
This is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Where's, oh, sorry.
The jury would also let me know when it's in the jury box monitors, or on the jury box monitors. All right, go ahead.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection, I'll consent to being called their name and leading the witness.
That's not my name. That's not my name.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion. How do you know that's Darrell Brooks there? His back is to us.
Objection, leading.
Shut up, bitch! Oh my God!
Overruled.
I've watched the video in its entirety, and I've seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Stop it, please.
Stop it, please.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each, so I would say probably 300 to 400 videos we have collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, we're not.
Objection, leading.
Arrête ça, s'il te plaît.
Arrête ça, s'il te plaît.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection, speculative.
I'm sorry, I gotta jump on this one. Objection speculative. To have you seen any photos? He's speculating to what? Whether or not he's seen a photo or not? Fuck, you're stupid.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Detente, por favor. Detente, por favor.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
やめてください。
Overruled. The witness may answer.
None of the videos that we have looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading and speculative.
Stop it now!
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
No, God! No, God, please, no! 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 No!
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
Overruled.
Good call!
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Objection, leading.
Oh, come on!
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. Just stated he wasn't there.
Objection!
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
I can't wait to see you explain this to a fucking Suffolk County jury, you fucking cocksucker. This is gonna be fucking fun.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Just fucking kill me. Just fucking kill me.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
No, stop, please! What are you doing? Please, stop! Please, stop! No! No!
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
Really, nigga?
My understanding that that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
They call me Stacy, they call me her, they call me Jane. That's not my name.
Noted. Overruled.
How did you get it?
Objection, leading.
Oh, no! Please!
Overruled. The witness may answer.
You just stated how you got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
No! No! No!
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department secure storage facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection, leading.
Stop it, please! I beg you!
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name. He's leading the witness.
That's not my name.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
That's not my name.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name. Leading.
That's not my name.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
I'd like to put on the screen for the witness only Exhibit 88.
Go ahead.
Do you see Exhibit 88, sir?
Yes, I do.
Objection to this. What's the relevancy?
Listen, talk to me. We can talk. Like, gentlemen.
Overruled. Go
Can you-
ahead.
Grounds for overrule.
Relevant.
In what way is it relevant?
Two of the counts alleged in this case. Go ahead.
Can you please identify Exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
No. No.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection,
is
leading.
No.
Overruled. The witness may answer.
2/21 of 2021.
Was Mr. We'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
Are you listening to me?
Overruled. The witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Please, don't do this.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
I want to help you. I want to help you get whatever you want. But you got to do what's right.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
I'm going to kill you. I swear to God, I'm going to kill you.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
It was
the...
already speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right, turn that
I
off.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue, Attorney Opper.
Thank you. I'd like to display for the witness only Exhibit 89.
Go ahead.
Sir, can you please identify 89?
Objection.
Yes! Yes!
Oh, as fun as this is, I'm gonna jump ahead a little bit. She just keeps asking questions about identifying Darrell. It's kind of pointless, so jump ahead.
Let's go back to Exhibit 175. Can you pull that up for the witness?
Would the state please pull that up? Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well. All right,
Just-
go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
Yes, because he's seen the video. You are playing with fire right now, sir. You'd be wise to let this go.
I don't believe that was my testimony.
I'm asking the question.
From just looking at this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment.
Dude, he just said it was you. The jury knows it's you. They've seen the car. They've seen you with the fucking dreads. This is so petty. He's gaining nothing. Like, okay, he can't tell it's you because your back is turned. But he just fucking established that it's you. We all know it's you. God damn. So pathetic.
Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now that you cannot tell who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? The usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And what? And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
for the
overruled. Go ahead and answer.
Can you repeat your question, please?
I don't think he remembers it. Yeah, look at him. He's like, fuck.
I'm gonna go another route on this.
You done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
That question alone has now given the state a legitimate argument to him opening the door to the music video. Based on that one question alone. He is just now asked to witness about a piece of evidence that, by his own admission, has not been made an exhibit. Any testimony he may extract about said video will have to at least be given an opportunity to refute by the state. Anything less would essentially be sullying the record. They're not giving both sides an equal opportunity to argue. He'll come on to debate whether or not this video is admissible, but by that statement alone, right there, he just brought it into the fray. They can't just let Darrell Brooks, master of fucking lies, paint whatever fucking narrative he likes about this music video. They can't just leave that unchallenged.
I testify that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety, what we recovered from your social media account. I'm not sure if there is a longer version someplace, but...
Did you see the video in its entirety? The video that this exhibit came from?
Yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
So, if this music video, just for hypothetical, all intents and purposes, were locked behind, say, a quote-unquote door, so to speak, and this cross-examination that Darrell is conducting would be an attempt at opening said door. That door is locked for his own benefit. There is nothing but hellfire and the forever sorrow of loneliness and solitude behind this door. You'd think that Darrell might be a little cognizant of the fact that tampering with this door is risky. An artful attorney had one been appointed for this trial, may artfully and tactfully sneak in through a window to grab one item in particular that's relevant. But Darrell is straight picking the lock in broad daylight, ladies and gentlemen. He wants in that house so bad, he is frothing at the mouth, just dreaming about stealing the TV in there. Suffice it to say, this line of questioning is less a jiggling of the doorknob, but more blowing it the fuck off the hinges. This is a fucking battering ram by a sloppy SWAT team attempt at getting through a fucking door. He has blasted it open. So we're going to jump ahead quick to the state's argument for admitting the music video as an exhibit. But before we do that, I just wanted to take a quick look at one moment I thought was kind of funny. So let's take a look at that quick.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe you said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
NANI? Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. Is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is.
I am 1,000% on Brooks' side on this one. Who is this man? Like, seriously, if you know who he is, let me know in the comments, because I have wondered that this entire trial. Why is he sitting there? I know she at one point looks over and says, like, my investigator over there, but Casey just said he's, like, not a cop. So what is he, like a PI? What are you doing there? He's right, like, nobody does know who he is. He's like fucking Voldemort, he who shall not be named, or Austin Powers, International Man of Mystery. For the first time in the trial, I'm on Darrell's side about something. Fucking 1 point on Darrell's side of the board for once. It's like 9,999 to 1. All right, let's jump ahead to when the state talks about the video.
Attorney Opera, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take that under advisement.
I'm objecting still because the
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Go ahead, Attorney Opera.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir. So let me see it, and I'll take your objection under. I'll take the objection under advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead, Attorney
Opera. I have all the exhibits.
Go ahead, Attorney Opera. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing. So
now we just create exhibits now. I have all the exhibits, and this was never in it. Oh, man.
All right, you can stop. Sir, do you recognize what's contained in State's Exhibit 178.
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness may answer.
I'm still gonna object.
I'm still gonna object after it's been overruled. I double object. I super object. I Kamehameha object.
Mr. Brooks, I ask that you honor the ruling that I've been made.
I have all the exhibits, though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take this up outside the.
Dude, you brought this up. This is because of you. You brought the music video into this, and furthermore, you have the fucking video. It's in your evidence. And fucking furthermore, you made the fucking video. What do you mean out of the blue? You're in it. You funded it. You wrote the song, you fucking jackass. I know that, like, you're the third-party interviewer, and this is Math Boy Fly in the video, and in Darrell Brooks' head, all of these people are different entities in your psychotic, schizophrenic fucking brain. But to the rest of the world, it's still you. They are all Darrell Brooks, and you are very fucking aware that you made this video. So shut up.
Presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the state may continue.
So this exhibit shouldn't be evidence then, because
Mr.
it didn't
Brooks,
exist
the
before
objection's
today.
noted. It's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Objection. How does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection. Leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
Objection to relevance. You asked him about it. What are you talking about?
I'll find that it's relevant. I'll receive Exhibit 168. Permission to publish is granted. For the record,
it's 178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that I didn't
Mr.
even
Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
it's
mind-boggling.
overruled.
Mind-boggling.
Oh man, and there it is. Another Darrell Brooks iconic moment. This is mind-boggling. This is mind-boggling. God, I love that moment. He's dumbfounded. In all of his years, he has never seen anything this egregious. Throughout his entire career as a litigator, his mind has never been this boggled. Darrell Brooks, ladies and gentlemen, attorney at law.
Who is the man in the suit? Who is the cat with the beak? Do you really want to feel him? Harvey attorney, habeas corpus, Marvy attorney.
My name is Darrell Brooks Jr.
Attorney at law.
actually, Your Honor, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played? Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about
about his knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
So play the sound. I want to hear it now.
No. You have tortured those people enough. Running them over was one thing, but subjecting them to your crap career? Your crap career? It's just a new level of torture. It's against the Geneva Convention. Frankly, you've tortured us all enough, sir. We don't need to hear it. Naturally fly. Oh, what's wrong? This is a 40-year-old man doing this. Look at him. This video kills me every time I see it. The fucking dollar bill hanging out of his mouth. He's got like 5 kids. They probably make better content than this. Look at him. He's such a little tiny man. He thinks he's so hard. Darrell. He put this up on his own channel too. Oh dear God.
Go ahead, attorney, after the video's finished playing.
Thank you. Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I did.
A lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The witness may answer. Sorry.
Yes, I was.
This poor guy's caught in the middle of this whole thing. He's got straight like little kid whose parents are fighting in front of him vibes. Like, leave me out of this, guys. I didn't mean to fucking start this whole thing. Poor dude. Gentle Wisconsin. You can just tell he's a kind soul. Good for you, Detective Casey. You can use, sir. As you were.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And
Noted. Do you have any questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection. That's not a question for the witness, Your Honor.
That was a question.
Sustained.
When was this
As to the
video
form
made
of
an
the
exhibit?
question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
That's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table? It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
they
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please, and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to
I'm
be
with-
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained.
It was
as to the
not
form
brought
of
up
the
in
question
the earlier
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I'll say with my
Objection, compound, asked and answered, misstatement of the facts, argument.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts not in evidence.
Sustained. As to the form of the question.
This is mind-boggling. This is mind-boggling. Can you clarify again why you viewed the video this morning?
Objection asked and answered.
So you're going to sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right. Thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason. Because you asked.
Man, you could feel that sigh from Judge Dorow in my bones. She spends so much of her time talking to him like a child. Sit down. Stop talking. Can you say please? Did you finish your dinner? No, you can't have a shower.
I see what you people are trying to do. It's not right. It's not fair and it's not right.
They are trying to convict you. It's being done fair, and it is
You can have a seat.
1,000%.
Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence.
Oh boy, Darrell is in man-baby mode, refusing to sit down. He too gangsta to sit, yo. He's too hard for a chair.
I never sit in no chair, essay. You never ever gonna catch me sitting in no chairs.
Like ese, you know that's loco, right?
I don't know.
It's cool, Carlito. No one's gonna think you're soft if you sit in a chair. Homies.
Yeah, yeah.
We're all sitting in chairs.
Hey.
Bunch of bitch-ass culeros.
All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Okay? I don't have no time to sit in no fucking chair.
Please sit down.
I feel like standing.
Man, all of you guys with your bitch-ass chairs.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I indicated I would.
Inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr. Brooks, I presume, and you can correct me if I'm wrong, but you're familiar with that video. Yes or no?
What does that have to do with what we're talking about?
Because I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that. What do you mean by it's
no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can make an offer of proof on that because obviously they marked it as an exhibit.
Well, with all respect, Your Honor, you're mischaracterizing what I said, and the record needs to be clear.
For somebody that is so concerned with keeping a clear and accurate record, he sure as fuck contributes to a lot of misinformation to contaminate it. From claiming he is a third-party interviewer, even though his license with his name on it is in said record, to making such misleading statements as, I am not a person, I'm a flesh and blood living human being. Fucking clown.
The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit? That was the issue.
Go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware. There's nothing that...
Hold on, sir. Stop interrupting. We have to make a record of it. You've interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me. Stop rolling your eyes at me. Stop mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you have throughout. I've seen it and I've made note of it.
I'm looking at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your
I'm
Honor.
gonna take that
And
as
just
asked.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet.
This is like two moms talking about a child like he's not even in the room. Just sit down and be quiet. It is fucking unfathomable the levels that Darrell has dragged this court down to. He has forced them down to his level. To where, like, opposing counsel is now making an argument for sit down and be quiet.
And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant.
Sue Opper would come to regret those words, as Mr. Brooks would then go on to misunderstand and misrepresent what these statements meant, and assume that because he literally cannot file stacks of sovereign scripts printed from the internet that he likely had to trade several cups of soups to obtain, would throw these words in the judge's face at every opportunity as evidence that the trial had been unfair and fixed. The irony in this, of course, being that the statement was actually a concise and poignant declaration of how the prosecution and the court are being completely fair and above board at every turn, to seemingly annoying levels.
You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely.
I was honestly kind of surprised that Opper didn't push back at the judge more for, like, the babying of Darrell the way she did. I mean, she has a very legitimate argument that all of his delay tactics and the arguing back and forth with the judge are hurting the prosecution. A very fair argument to that fact. And Darrell slipping in all these comments about judicial misconduct and you guys ain't being fair and stop being slicked in front of the jury, or they're 1,000% tainting the jury pool. You know, whether they believe it or not, they can't unhear it. It's like if you take a drop of shit, like if you take a drop of like diarrhea, like liquid shit, and you dropped it into the metaphorical jury pool, the water in that pool may be big enough that you can't taste or smell the shit, but it's there. And once it's in there ain't no getting it out.
The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibity, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word Exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
Oh my god. Oh, this stage is killing me. I object to that. Talk about me so fucking tone deaf. He's like completely incapable of seeing himself through someone else's eyes. He's gonna continue to object at every turn. I object to that. Fucking Darrell.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
I'm sorry. No, it's not. The judge is supposed to make rulings based on, like, filings and motions. You know, that's what these breaks are meant for, but this trial has been brought down to such animalistic levels by Darrell's nonstop gaslighting and bullying that they literally need to take frequent breaks just to dispute everything he's saying. That's why it's so hilarious to me that Darrell is so focused on keeping the record clear and accurate, because he's the only one gunking it up. There's probably a fucking 3-ring binder buried in a stack of legal boxes somewhere, filled to the brim with pages of Darrell Brooks saying, "That is not my name, I don't consent to saying that's my name."
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up 2 other issues. There was an objection to questions regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
She's trying to distract him because she knows he's about to go on a fucking tirade. God bless you, Judge. You cannot stop this. This is like an avalanche. There is absolutely no fucking chance he's stopping now. There is no way in hell he is leaving those comments unchallenged. His ego will not allow it. Let us not forget, he held up court at the start of this day for like 10 minutes because of this issue with Detective Casey. He refused to call his first witness and more or less held the courtroom hostage because it was so important it couldn't wait until a break, and now he's just ready and willing to brush it aside and forget about it, all for the opportunity to refute Opper's statements. This man is so blindly beholden to his own emotions, he's a slave to them, to his own detriment.
Am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about.
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
So I think it's obvious to all of us that it absolutely does. And he is definitely acting out because he's panicking. I'm going to cut to a clip of his mom, Dawn Woods, who, let's face it, is a Darrell Brooks argument master. She's got a PhD in the matter. She's got 40 long and storied years of being tortured by this man. Going back to when he was Baby Brooks, and his first words were, "I do not consent to being called by that name."
I can see the storm coming.
That storm Dawn Woods fears is another emotional, manic outburst from her son Darrell Brooks once his homicide trial begins Monday.
Shouting, it's acting out, it's throwing chairs, it's destroying things. It's all of the above. It's like someone setting off a time bomb.
Dawn has been trying to defuse that time bomb for 40 years. She speaks with Brooks every day from jail, but says recently his tone has changed. The stress and pressure are getting to him. She fears he's falling completely apart, headed toward a psychotic breakdown.
I've been hearing Darrell slowly slipping for the past 2 months.
Brooks has bipolar disorder and personality disorder. Dawn says without his medication, Brooks gets explosive when he panics or is afraid. And she said the manic episodes can last for days or even months.
I don't know when the manic is going to end and how far it's going to go.
So, first of all, I don't put any stock into her claims of bipolar. The judge reads 4 psychiatric reports at sentencing that basically disputes that. The personality disorder, sure, but it's clear she uses mental illness as a placeholder for my son is an asshole. It's a coping mechanism. But now we see how Darrell reacts when he's scared or panicking, right? He's acting out. She predicted chairs getting thrown. The defense is pretty close to resting their case at this point, and the evidence is absolutely stacking up. We just heard it from the man's mother himself. When he's scared or panicking, he acts out. He does this frequently throughout the trial, but we're seeing it live now, even though he's disputing it. I've talked before about how days 15 and 16 were his most explosive, and it's because those days were designated for his defense, in which he was slowly realizing he had none. That day, day 15, when we see the stare down and your life is not on the line, and then, day 16, the whole box fort episode, he's bringing the ruckus because he's terrified. Those 2 days are most disruptive because all of his witnesses basically testified that he was the driver. They did nothing but help the prosecution. And what he sees is basically his strongest defense, the sovereign scripts. They weren't even admissible as evidence. Based on what Dawn is saying, this is actually kind of reserved. She predicted chairs being thrown and breaking things, and I'm honestly kind of shocked we didn't see it.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No. What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key.
Oh, that made me mad. Every now and again, he just fucking says something and it really pisses me off. And that fucking key. God, he's so fucking annoying. I'll take solace in the fact of knowing that she is living in this man's head rent-free. She probably is not laughing at him, and he's totally letting it fucking spiral out of control. He's making a mountain out of a molehill here. Yeah, she's living in his head, that's for sure.
That they've been doing that the whole time. I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras are for.
I can assure you the cameras are to not catch lawyers laughing. Ugh.
Let's refocus our attention on what we're here for, and that's
this
trial.
Then I take that
do you have anything you want to put on the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not that she just said, she just made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm
What
not
do I need legal basis for when she just admitted on the record that she just made this exhibit up right now?
That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't implying that by saying that she could pull anything out of her suitcase.
So that's a figure of speech.
Okay, so what is it implying to? What would that be implying to?
How would anyone in my position? Because you're not providing me with any legal basis.
I didn't even finish. You told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my decision to admit it,
I just said that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either.
Can I finish? Please, can I finish? Okay, I'm finished.
Because you're not providing me.
But how do you know I wouldn't get to that if I finished?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
So I'm supposed to come up in here and like act as my own attorney and make arguments that are based in law and logical? I'm supposed to like have a basis for my argument? Like make sense?
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that? My name is Darrell Brooks Jr.
Attorney at law.
The bottom line is you open the door to the playing of that video.
We're not talking about opening no doors.
And the video was previously provided to you during discovery.
We're not talking about opening no doors. We're talking about being fair.
There's absolutely no prejudice to you,
Your Honor,
in terms of surprise.
With all due respect, if I had done that,
I am going to move on.
If I had done that, it would have been a big thing.
I'm advising you.
Are you asking me?
I'm advising you, sir.
Oh, okay.
I'm advising you to sit down and be quiet.
Yeah, I don't know what that means. I'm too gangster to know what that means. No one thinks it's for pussies.
And if you interrupt me again, you are on notice that you will forfeit your right to be present in this trial.
So you're holding me in contempt?
Mr. Brooks.
For the entire trial? Did you say the entire trial?
I never said any such thing.
You said for the trial.
Please?
So what do you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to come at me.
I don't consent to being called
that. You continue to fight with me.
I'm not fighting with you.
You are being disrespectful.
I'm not fighting with you. I'm not.
I'm going to give you one last opportunity to sit down and be quiet so I can make a finding as it relates to other things.
Are you asking me to do that?
I don't need to ask, I'm telling you. Thank you. There were 2 other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time, and if you don't answer it
if I don't
correctly, then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
it calls for a yes or no.
I don't like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down. I don't care if you don't like my tone. You've been pushing my buttons all day throughout this entire trial, and I have showed the utmost of respect for you, and I don't appreciate you impugning the integrity of this court.
If that's what you want to call it, that's fine, but it's not accurate.
Stop talking.
What you mean, stop talking?
I need to make a ruling. Okay, well, I'm purposely not putting you in the other courtroom
right now. Let's talk to
each
other like adults then. Because I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the question about the jail cell?
He's not answering my question. We'll move on.
I'm trying to understand.
Lester's got Cena! The F5'd!
Oh, man. Oh, boy. All right. This has been fun, guys. That's going to do it for this one. Before we go, I just want to say thanks again for all of you for watching it this far. If you're not a subscriber, I highly persuade you to subscribe. The channel's growing. We're a little Squirrel Pup family. Join us. I assure you it's nothing but love. Leave a comment. I'll do the best I can to respond to them as always. I've got super chats now. If you enjoy this content and you have some extra money you can contribute, it would mean a lot. This is basically like a full-time job on top of my other full-time job. I mean, don't get me wrong. Look, I love doing this. This is like my favorite thing. But, I mean, the script writing, all of the... forget it. It's fine. Have a good night. I hope you enjoyed it. We'll see you in the next one. Drop me a like. How about that? Is that a fair compromise here? All right. Can I ask for that? Is that okay? Can you like this video? Thank you. Thank you. See, that wasn't hard. How easy was that? All right, guys. We'll see you.